Good morning, ladies and gentlemen. Thank you, Mr. Jerry. I'm very glad to be here, and I'd like at first to congratulate all those involved in planning this United Nations Principles and Guidelines, the first global instrument to deal specifically with legal aid, which represents a significant progress for effectively delivering fundamental rights and access to justice services. I'd like also to congratulate the organizers of this first international conference on the theme, which has the ultimate goal of transforming these principles and guidelines into reality. To do so, I will turn to some issues that I consider of paramount importance. The first one is the establishment of an international standard according to which those eligible to the legal aid are not only the extremely poor or indigent people. Secondly, the document makes clear that the legal aid system must be prepared to provide assistance to groups of people in position of vulnerability, acting not only through legal action, but also committed to legal education, access to legal information, and out-of-court activities, reinforcing the idea of a comprehensive and full legal aid. The third critical item is the recognition of the centrality of the legal aid system, which should be in the state's constitution, therefore recognizing its nature of a fundamental right. Hence, to avoid that this system become a mere set of rules, the UN principles and guidelines assert that the states should allocate the necessary human and financial resources to the legal aid system in order to organize a quality service. The states are therefore urged to figure out a criminal legal aid system most suitable to their situation, observing the quality standards, a wide accessibility, and the independence that the legal assistant should always offer. Due to the time constraints, I briefly will describe the Brazilian experience. I'm a public defender in Brazil. I'm a member of the National Public Defender Association and public defender in the state of Rio de Janeiro, Rio, where the World Cup is taking place now. Talking about our Brazilian Constitution, in the chapter about fundamental rights, the 1988 Federal Constitution of Brazil sets out the duty of the state to provide full and free legal aid to those with insufficient funds. Under the chapter Essential Functions to Justice, the Constitution establishes that the Office of Public Defenders is the Brazilian government's authority in charge of delivering full and free of charge legal aid to those who cannot afford to commission a private attorney. This type of legal aid should be delivered both in and out of court and should cover all fields of law and all judicial levels. The Brazilian Constitution also determines that the Office of Public Defenders is an independent institution made up by previously selected professionals. There's a problem here. It's the first time I changed it. Not using papers, but the electronic device. Not a good experience. Here I go. The Brazilian Constitution also determines that the Office of Public Defenders is an independent institution made up by previously selected professionals earning a salary to work full-time, entitled to the same treatment given to judges and prosecutors. From a historical point of view, it's worth noting that the Federal Constitution of 1988 restored democracy in Brazil after more than 20 years of military dictatorship. The so-called citizen-oriented Constitution has placed individual and social rights as well as their guarantees at the center of the legal system, proclaiming the general principle of human dignity. Before 1988, the different states of the federation, we have 26 different states in the federation, Brazilian federation. The different states of the federation put into practice different models of legal aid. For example, the Office of Public Defenders of the State of Rio was set up in 1954 to provide state service through full-time attorneys earning a monthly wage. On the other hand, the state of São Paulo, in the state of São Paulo, the prevailing system consisted of a collaboration agreement with the Bar Association, which appointed attorneys to work in court cases for a fee paid to each suit filed. Comparing the two models, it was estimated that the total cost of the work done by those attorneys was higher than the cost of maintaining an office of public defenders, which was also superior in terms of technical capacity, as continually recognized by our courts. Based on this, and convinced on the importance of setting up strong public institutions focused on defending fundamental rights and democracy, the original working of the Constitution of 1988 attached weight to the offices of public defender and, even more, to the prosecution offices, taking them off to the control of the government and building independent institutions. As a result, the prosecution office expanded and gained strength outright, whereas the establishment of an office of public defenders was really slower. By as late as in 2006, there were no public defenders in 5 states of Brazil among its 26, including the big state of São Paulo, the richest and the most populous. In all these 5 states, there was a common reason. Groups of attorneys were not willing to accept such a shift, since they believed that the setup of an office of public defenders meant the end of a supplementary source of income. Actually, besides this collaboration agreement with attorneys, there was an official department called Legal Aid Office in São Paulo, which represented the very inception of the offices of public defenders. Studies conducted by the state attorneys pointed out that in the year of 2004, the 300 attorneys from the Legal Aid Office assisted 15% more people than the 43,000 attorneys working under the collaboration agreement, even though the legal office accounted for less than half of the state's spending compared to the collaboration agreement. Also, this study does not discuss the other fields of activity of the public defenders, which cannot be found in the private model, such as out-of-court activities, education on rights, and the class action suits. However, the financial outcomes were not the only aspect that encouraged the setup of the public defenders in São Paulo. A significant portion of the society called for an institution specializing in legal aid, empowered to file individual and class actions, to promote education about rights, alternative mechanisms of dispute resolution, and capable of handling sensitive issues such as prison systems and urban and rural land disputes, among others. In 2002, the city of São Paulo started up a civil movement for the Office of Public Defenders that was supported by more than 440 society organizations, which, after 4 years of intense work, have successfully approved the setup of an Office of Public Defenders. The first one to be clearly open to participation of society groups through an ombudsman office, advisory board made up of members of society, and annual conferences open to the public and draw up the public defense guidelines. Nevertheless, the collaboration agreement with the Bar Association did not cease to exist, and years later, this agreement was under massive court discussion. Across Brazil, it's very important to say that civil society pushed for an Office of Public Defenders to be made stronger. And since the year of 2003, this issue was included in the priorities of the constitutional and judicial reform approved by the Brazilian Congress in 2004, including the administrative, financial, and budgetary autonomy that enable the Office of Public Defenders to fulfill its constitutional duties with effective independence to file suits even against the state. It means that Office of Public Defenders has been able to recruit and manage its staff and choose its own leaders through internal election. Besides this, new skills, roles, and powers were given to the Office of Public Defenders, including the power to file suits in international courts of human rights. These important steps taken by the legislative branch have been strongly supported by the Brazilian Constitutional Court. In 2011, the Brazilian Supreme Court ruled unconstitutional the provision set out in the law of São Paulo's Office of Public Defenders, which determined the mandatory use of public funds to pay attorneys' fees. In one of the most important precedents of the Brazilian highest court on the issue of access to justice system and its funding, the court upheld that it's the constitutional duty of the state to provide free legal assistance to those who do not have the means to commission an attorney. Therefore, the Office of Public Defenders has been elected to the federal constitution as the single state authority with powers to regularly fulfill these duties. Hence, any public policy that diverts people or funds to another entity with the same goal, to the detriment of the Office of Public Defender, infringes our Constitution. In this trial, the Supreme Court discussed the most appropriate model for Brazilian reality, emphasizing the idea of an integrated system represented by the Office of Public Defenders. Concluding, broadly speaking, this is the Brazilian experience, and also the same, more or less the same, in Latin America, all over Latin America, as we could see in the morning. And it's a trend toward the adoption of the model of public defense. No matter the model of legal aid adopted, the fact is that it's unacceptable that in the 21st century the states organize a system of criminal justice or even civil justice solely based on judges, prosecutors, and private attorneys. Without the presence of a legal aid service equipped with a consistent structure and budget, thus ensuring the principles of equality of arms as an inherent component of the right of a fair trial. Thank you very much.